Honorable Attorney General and Minister of Legal Affairs.
Thank you, Mr. Speaker. Mr. Speaker, in 1996, we enacted the Domestic Violence Act. That is some 3 decades ago. And it was a groundbreaking legislation at the time. And 30 years hence, we would have been able, through experiences and through use of the Act, identified deficiencies, loopholes, and inadequacies. In addition, 3 decades after, society would have evolved, new concepts emerge, new social and legal realities emerging. And that also will require us to expand the legislation if we are to review it. And the bill that is before us, titled the Family Violence Bill of 2024, Bill number 11 of 2024, does just that. Everything that is, almost every concepts, precepts, protection orders, and categories of persons, as well as offenses, wrongs, types of abuses, etc., contained in the Domestic Violence Act of 1996 have been retained. What we have now is an expansion, adding broader context, defining in broader terms the contextual setting, increasing the number of orders that can be made, increasing the jurisdiction of the courts, giving more additional powers to the police, etc. All of that are now in the Family Violence Bill. And let me address the Honorable Natasha, who's not here. It's never the intention of our government, or the intention of any government, or the belief rather, of any government, that legislation is the panacea of all problems in the society. It is not. It certainly is one of the solutions. And that is what we are putting forward. The Honorable Member Annette Ferguson spoke about a white paper in 1980 on women. Doesn't necessarily, I don't know what is the connection between that paper and family violence. Family violence is much wider than the rights of women. Obviously, it includes women. The Honorable Member Natasha spoke about another white paper. That's all that they speak about. Papers and concepts and reports, studies, and we have all of that. We have all of that, but we are bringing them into fruition. And that's the difference. We are moving from the theoretical stage to practicality. And that is the difference between the two governments. One is always doing a study. They did a study of the Demerara Harbor Bridge. They produced a report with a 1-lane bridge. We are building now a 4-lane, 1,000 feet in the air. That's just one example. One example of the difference. But let's get back to the bill. So, Mr. Speaker, the domestic setting, which was created by the Domestic Violence Act of 1996, has been widely expanded to include a familial setting. It's not that we are detracting from the imperatives of domestic violence as contemplated by that act, but the domesticated environment is now expanded far and wider than it was expressed in that bill, to take into account categories of persons that may have been omitted at that point in time. So you have a wider category of persons who will benefit from protection under this bill. Secondly, we have the type of orders. You have now a wider range of orders that one can seek under this bill. Wider regime of protection. Inherent is that in that, obviously, we have widened again and increased the definition of what family violence is. If you look at the Domestic Violence Act of 1996 and you look at the offenses or the wrongs under that regime, and you look at the wrongs and the type of abuses under this legislation or under this bill, you would see an appreciable expansion of the type of abuses that this is catered for. The Honorable Member Annette Ferguson spoke about harassment. And while we have a harassment bill coming, clause at page 7 of this bill, it speaks to harassment, and it includes intimidation of a person by persistent verbal abuse, threats of physical violence, malicious damage to property, inducing fear of physical or psychological violence, or any other means. The persistent following of a person from place to place, the hiding of any clothing or property owned or used by a person, or depriving of a person of the use thereof, or hindering a person in the use thereof, watching or besetting of the house or other places where a person resides, works, or carries on business, or happen to be, or watching or besetting the premises that are the place of education of a person, or watching or besetting of the approach of the person to a house or other place of education, making persistent unwelcome communications to a person, texting, WhatsApping, using abusive language to or behaving towards a person in any other means which is of such a nature or degree as to cause annoyance to or result in the ill treatment of that person. So I read that out for the record to explain the breadth and depth of that singular definition of harassment. And this bill has a series of definitions of that type, so as to encompass the widest conceivable type of wrongs, abuse that can be perpetrated and take place in a domesticated familial setting. And of course, I wouldn't go through the meaning of family violence. It spans an entire page, 2 pages rather, of the bill, page 10 and page 11. Again, the breadth and depth of the bill. And then the objects of the act. And then, of course, the type of orders. And as I said, there are several pages of orders that can be made. The type of orders, they can be made ex parte, meaning in the absence of the other side, depending upon the urgency of the case. They can be made inter partes, in the presence of the other side. They can be made for periodic intervals, depending upon the justice of the case. And of course, they can be made permanent. And it has inherent protection for other interests that may be affected. So we have, for example, a tenant order. This means that if the husband, one party is a tenant, meaning that the tenancy agreement is in that person's name, if that person is excluded from the matrimonial home by a protection order, the beneficiary of the order becomes the tenant, but it doesn't defeat the rights of the landlord. That tenant will have to continue to pay the husband the offender being ordered to pay the rent and comply with the obligations. The point I'm making is that third-party interests are protected. And the Act also emphasizes that whatever orders are made against the offender, it does not affect ultimately their proprietary interest in a particular property. So they are protective orders only to meet the justice and the vicissitudes of a factual situation unfolding so as to offer protection. But it does not go to defeat the proprietary interest. What that means, for example, is that a protection order that excludes the owner of a house by transport doesn't mean that he's no longer the owner of the house. It doesn't mean that his proprietary interests vested in him by that transport or certificate of title, as the case may be, will be defeated by the court order. Obviously, you can't do that. That would defeat the man's constitutional right or woman's constitutional right to own and enjoy property. So all those interests are protected in the bill when these orders are made. And of course, there is also a regime that allows for the discharge of these orders, because the bill also contemplates a vexatious applicant or complainant. Not every time you will have a bona fide complaint. You have malicious people too, who would like to rush to the courts, and we have had experiences like that, manufacture a story and get very invasive orders and very draconian orders made excluding persons from their house wrongfully. So the bill caters for those persons to come back to the court and for the court to discharge orders based upon evidence. And of course, to make an order to avoid vexatious litigation. Perhaps the most significant feature or addition to the bill is the powers that have been conferred on the police. And these were deliberately done having regard to the experiences under the Domestic Violence Act. The Domestic Violence Act, in its current construct, really contemplates an application first being made to the court, then action being taken. So the police really had limited power. If you look at the current legislation, they had basically the limited powers that they have under ordinary criminal law of assault, battery, grievous harm, etc. This bill gives a huge addition of powers to a police to do many things. Remove the applicant, for example, or the complainant from the place of the violence. Go with the complainant to help them move out, or can take steps to remove the violent offender from the place, ensure that children who are involved are protected. So, and all of these, the police is empowered to do long before an application is even made under the Act. These are preemptive powers that the police now has, which they didn't have before. And these include the power to enter premises without a warrant. Now, and that's a serious thing. You may see a domestic violence situation taking place, and because it's domestic, it's private, even though the police may have certain common law powers and even statutory powers to stop a violent offense from taking place, they are timid because it's domestic, it's private, going into private property, carry with them certain risks. Those matters have been addressed frontally, and the police here is now empowered in appropriate cases to do that. Many of the cases of domestic violence fall through unless there is a lawyer for prosecuting it. This bill puts into place a mechanism that allows for a person who may not have the benefit of legal advice to be able to prosecute the case. And that is why it imposes on the police a duty to take adequate notes of the reports, preserve the evidence, prepare a special report, and hand it to an officer in charge, the police officer of the highest rank in the police station, so that the evidence is preserved. Many of the times, as I said, the reports are taken and that's the end of the matter. Here you have a different regime that allows for a different treatment to be meted out. In addition to the civil type of orders that now can be made under the Act, you have criminal proceedings. So while the previous Act, the Domestic Violence Act, was more civil in its nature, and you only really get imprisonment when there is a breach of the order, you have these offenses created by this Act now are criminal in their very nature. So when you go to the court, not only will you get a regime of civil order protection, but the police can charge the offender for criminal offenses for which they can be sentenced and jailed. So there's a different regime of offenses being created. And also, this bill, unlike the Act, creates civil cause of action where you can claim compensation for domestic violence. So apart from the injunction that you can get, the protection order that you can get, and the various other remedies that you can get, you can also get compensation. And an action for compensation is maintainable simultaneously with the criminal offense that the Act creates. And it is not an abuse of process to file both criminal proceedings and civil proceedings arising out of the same misconduct. And the Act makes that explicit, because some smart lawyer might say you can't pursue criminal proceedings and civil proceedings at the same time arising out of the same incident. The bill puts that to rest. Also, the bill, which is another addition to the Domestic Violence Act, is that it invests in the High Court, the Supreme Court, not the High Court, the Supreme Court, with all the powers, and it equips that court to grant all the orders that can be granted in a magistrate court while proceedings in relation to the parties are ongoing in the High Court or in the Supreme Court. Why I say Supreme Court? Because the Supreme Court consists of the High Court, the full court, and the Court of Appeal. So even if you have a divorce proceedings and the occasion warrants a protection order, you don't even have to make the application in writing to the judge. You can make it orally and the judge can grant the order. Under the old Act, you had to go to the magistrate's court and make an application in writing. Now you don't have to do that if you have family court proceedings already pending in the High Court. And you don't have to file necessarily additional paperwork. You can invite the court to make an order, an appropriate order, in those proceedings itself. And you can do that even while an appeal is going on. Domestic violence, as we know, does not end. Familial violence, they don't end. Court proceedings don't necessarily end them. One time I spoke in this parliament and I made reference to a case on the East Coast where the man got from the magistrate court, or rather the woman got from the magistrate's court, an order removing the offender, the husband, from the house. The husband was served with the order. He had the order in one hand and a cutlass in the other hand. And he went back into the home and he chopped the woman to death and then killed himself. That is a classic case where the law alone can't work. But that's not for this debate. This debate is about the law. We have a lot more work to do. So you mustn't burden this debate with those matters. We know that. How many bills have we not brought here to deal with traffic and the carnage on our roads? Have the carnage stopped? No, they haven't. We have brought many bills here dealing with violence. Have the violence stopped? No, but this is one measure. Mr. Ramjitan supposed to bring some horses and dogs to fight crime. I remember that. The horses never came, the dogs never came, and the criminals are still with us. But that is an aside. So we have to, these things are holistic. But this here is an important measure towards a solution. It will not bring about the solution. So, Mr. Speaker, I know that I am running out of time. I don't wish to detain you. But in the bill also, you have an obligation being imposed on the police force and many other agencies that would come into contact with victims and offenders. And they have a duty to advise on how, apart from charging, to seek remedial help at the various state agencies, government departments, etc. And as the distinguished minister, Dr. Vidya Prasad, made reference to the Hope and Justice Center, which we are creating, you have those facilities as well. So when the policeman, if he can't find the domestic violence, the report is made, the person, it's a weekend, so you can't get a magistrate. Where do you put the victim? You may not even find the offender to lock him up. And you have, the victim will tell you that there is every likelihood that he will come back 1 o'clock in the morning and do more damage. It's hard to get a policeman to stand there whole night. We have places across the country where the police can take the victim until proper arrangements can be made. Those are duties now, by law, that have been imposed on the social workers and the police when these situations occur. And of course, we have the minister having a power to make regulations, to even give greater teeth and greater flesh to this bill if the occasion arises. So, Mr. Speaker, with those brief remarks, I commend this bill to the House. Thank you very much.